actually left the case once for non-payment. Had to come back on.
All right, we
as
are
he
on
begged
the
me
record.
because-
462464, the Gibb matter. Mr. Willick, your appearance?
Good morning, Your Honor. Marshall Willick, 2515, for Farrah Kaufman, who at least a second ago was is present on Zoom. Blue Jeans.
All right, thank you. Mr. Gabato?
Good morning, Your Honor. Alex Gabato, 10592, on behalf of Kristen Gibb. He is not present, Your Honor. He is on flight duty, I think, right now.
Okay.
Also present, Richard Crane from my office.
Oh, there he is. Okay.
9536, Your Honor.
Thank you. All right, we are on today at the request of counsel to resolve an issue relating to the life insurance, potentially in lieu of the SBP. Sorry, the acronyms are all coming together. So I did review the email. Is there any update to the process at this stage?
Yes, Your Honor. There's actually just a couple things that I don't think have been made clear. So it'll only take me a minute. But the last update we had is that there's been no further word from the insurance company. We just can't force them to make a decision. And I understand you've got a tight calendar, and I don't want to necessarily hog the matter, but there are four things that I'm not sure the court knows that I would like to go over, and I don't care in what order people talk, but there are four things I'd like to be able to say before you rule.
Okay. Well, what I know of the issue is what's contained in the email string that was provided to my staff. That's all I know. So if there's more that I need to be made aware of, now would be a good time to let me know.
Then, if the court permits, I'll simply start, and Mr. Gabato can respond, or would you prefer a different order?
Mr. Gabato, you have a preference?
That's fine with me, Your Honor.
All right. Mr. Willick, go right ahead.
If you saw the emails, then you understand the issue, and the question really is a risk allocation question. Who should bear the risk that the insurance won't be approved, and therefore there won't be that private insurance policy available for one of two people? To make sure we're all understanding the situation, and with no disrespect to any of the people, just to keep it straight, I'm going to be referring to Farrah as wife one and the current spouse as wife two, just so we can keep track of who's who. When you allocate, well, the question for the court is really allocation of risk. We think that given the history, if there is a risk to bear, it's most appropriate to fall on Mr. Gibb. That, of course, is a decision for the court. But the three other things that the court needs to know that I don't think the court knows is the equitable factors that can impact this decision. First, wife one has the largest time rule interest. She has the largest interest to secure. They were married for just about 14 years of active duty time. So in terms of risk to cover, wife one should prevail. I've had CLE materials out there for about 20 years, and a index was suggested for how to make decisions between wife one and wife two. I could, of course, provide that if anybody wants to see it, but we didn't make it up for this case. We have been lecturing for decades that the logical way of allocating the SBP when there are two potential claimants to be benefited by it is who has the larger interest to secure. And in this case, that would be wife one. The two other things that I don't think the court knows is that Mr. Gibb has a ready ability to obtain insurance, even if this insurance fails, for his current spouse because of the military. He currently has something called SGLI, automatically as a member of the Armed Services. It stands for Service Members General Life Insurance. It is convertible upon retirement to something called VGLI, or Veterans General Life Insurance. It is automatic. He cannot be turned down. It's a matter of a federal entitlement. And the other curious thing about this insurance, which is why, because I think I know the court might immediately go, well, why don't we use that one, is we can't. there is a United States Supreme Court case from 20 years ago that says that no court can make a binding order for SGLI, VGLI beneficiary designation. In other words, he could stipulate and you could order and everyone could agree that Farah Wife 1 would be the SGLI beneficiary. He could turn around the day after the court order, change the beneficiary designation back, and according to the U.S. Supreme Court, there is nothing in the world you could do about it. No constructive trust can attach. You can't force him to change the beneficiary designation. It's literally an unenforceable agreement. And I'm not saying that to be mean to anybody, and I'm not accusing anybody. This is just the law that I don't think anybody else knows. And again, if there was a question about it and anybody really was doubting that this is the way it is, it's in our CLE materials and it's been there for 15 years. So we can supply that upon request. But I don't know that anybody is going to contest that that is the state of the law. The last thing, and this is the one that we think is really the kicker, is comparative total cost. There is a weird loophole in the law. And if we arrange this situation so that Farah is, wife 1 is the SBP beneficiary, and wife 2 is the insurance beneficiary under the VGLI, SGLI, then we only have to buy one policy. If we flip it the other way, so that we use private insurance for wife 1 and we use the SBP for wife 2, there will be 2 premiums to pay. And the explanation for it, again, is in our CLE material starting at page 128. And it goes like this. Because it's a little counterintuitive, so I'd like to step through it. If a former spouse remarries before age 55, the premiums are suspended indefinitely for the coverage provided by the order. It's not lost, it's not terminated, it's suspended. And it's suspended throughout that former spouse's second marriage. The illogical part is really what happens if there's a further change of status. If the former spouse's later marriage terminates, the former spouse regains eligibility for the SBP, and the premiums again become due. But there's no provision in federal law for recoupment of the prior premiums in that circumstance. So the period of suspended benefit, even if many years long, is completely free to both parties. There's no SBP premium for this coverage. And the effect is even stranger if the member dies prior to the date that the former spouse later marriage ends. If the member is deceased and the former spouse's later marriage ends, the former spouse resumes eligibility and immediately begin claiming the benefits. But since the lifetime stream of payments ended with the death of the member, no premiums are deducted from any retirement benefits. And the SBP benefits are received without any premiums at all ever having been paid for the benefit from the date of the former spouse's remarriage until the date she begins receiving the benefit after that remarriage ends. Okay. I know that's counterintuitive, but that's what the regulations provide.
Well, Mr. Willett, maybe I'm looking at this too simplistically then, listening to your argument. But I thought I resolved this issue at the last hearing, that he had 30 days to get a life insurance policy or he was going to have to put her on. So is it more difficult than that?
Well, yeah, I mean, I don't want to speak for Mr. Gabato, but I'll let him give his argument. His argument basically is that his guy has done everything he can do. And
yeah, that's basically it, Your Honor. That's true, and that's what I was going to say as well, is that it is a little more simple than, I think what Marshall's doing is giving you a lot of options if you decide that what you're going to have to do is make some ruling because life insurance isn't available, but that's not the case. It is. So 2 things. My position first is that he did what you ordered him to do. He went and he took he underwent a physical and he cooperated with his ex-wife to make that happen. And in fact, he's been pushing the insurance company and the person that he was in contact with there to do it as quick as he possibly could. I have evidence of that. Right now it's with underwriting. There's no indication that it's going to be denied. There's just, when they inquire, and my client has also inquired with the contact that he had as to what the status of it is. It's basically, it's with underwriting, and it's a sketchy situation because of COVID and because he's overseas. But that's it. That's the word. My position is my client did what you told him to do. He cooperated, and he did what he had to do to get life insurance. There's no guarantee you're ever going to get life insurance. He could have a disease that they're not going to insure. The problem here is that Ms. Kaufman waited for 8 years to do anything, and that's why we asserted latches in our briefing, because that's the reason latches equitable estoppel exists. If you wait that long, people move on with their lives. And in this case, Chris married, and he decided to award his new wife the SBP. She's already, at this point, she has a property right to that. I would say that if you're going to deprive her of that, she should have some say in it.
Well,
but it's not necessary.
Judge Duckworth did that. That wasn't me. I'm just enforcing his order.
Well, the point remains, even if it was when you guys when they ended up back in court back in 2015 or 16, at that point she waited 4 years. That's the reason you don't wait to do these things, because people move on with their lives, and other people. You make promises to other people just like he did with his wife, and now here we are.
Well, and Mr. Gabato, I totally agree, but it feels like that I'm being asked to make the same decision over and over and over again, rather than moving forward with the decision as it's been put in place. So I guess what I'd like to hear from you
he's cooperating, and he can continue to. I'm sorry, Your Honor. Go ahead.
I said what I'd like to hear from you is, why don't I just enforce the order? He didn't do it within 30 days. It's been more than 30 days. Isn't there already an order in place with regard to that issue?
Well, because he did. That's the question: is what did you order? I think rather than ordering that life insurance happen, you can't order him to make life insurance happen. It's not up to him. The underwriters have to approve it. What you ordered him to do, from my point of view, is essentially. Sit for the exam. Do what you have to do for the underwriters to make a decision on approval or non-approval. If you're saying that you ordered them to get life insurance, but it hasn't happened in 30 days, well, what's to say that, maybe your ruling was impossible under the circumstances and unenforceable? Because if you're ordering somebody to get life insurance within 30 days in the middle of a pandemic, when the guy's in the military overseas, it complicates things. And now you entered an order that is impossible to enforce.
It's not.
So I would ask the court to consider that.
What's that? No,
it's impossible for my client to comply. Well, it's impossible for my client to comply if you're giving him 30 days to obtain insurance in the midst of a pandemic and when he's overseas.
Okay.
When that's going to complicate things.
But Mr. Gabato, the information I have is that if wife one does not exercise the rights that are contained within that order in the near future, they will be lost. Is that not your understanding?
Well, it's not going to be lost, because what she's trying to do is obtain life insurance, not the SBP. The SBP, the argument, I don't think that we fully argued that issue, because I think the argument was that it was an omitted asset. We disagreed that it was an omitted asset, hardly an omitted asset. I think what your solution was, look, go get the life insurance and your wife could get the SBP. So he went about doing that. It's just that it's taken longer, not because of him, not because of anything he's done. It's just taken longer because of the circumstances that we're in.
No,
that doesn't mean that he's not ever going to get life insurance. So in other words, it may be the case that if we just waited 30, 60, even 90 days, he's going to get life insurance. But if you deprive his existing wife now of a property right that she's entitled, or she thinks that she's entitled to, without even her appearance here, it's problematic, I think.
Well, here's it's not the question that I asked, and I probably asked it inartfully. But the information I have is the window to name wife one as the SBP beneficiary closes in about a week. Is that your understanding?
That is what my understanding is from what Mr. Willick has told me. I'll admit that Mr. Willick knows far more about these things than I do. I don't know that that's the case, in all honesty. I don't know the rules regarding when those things close. I would submit that Mr. Willick is the expert. Honestly, I'm just taking his word for it here.
Okay. Well, and I guess that's where I'm at is I do I take his word for it as well? That's why I need to know from you where we are. Because if that is the case, then it nullifies one half of your client's options that I gave him at the last hearing, which causes me to go the other direction. If that's not the case, then certainly we have time to let the underwriters do whatever they're doing and allow him to take that side of that option that I gave him. So that's where I'm concerned
how
today.
about,
And that's
can
what I
we do
can.
this, Your Honor? I don't think we need another hearing, but maybe if you allow me to submit something and look into the issue and determine if that's in fact the case, because it's true, I don't know, and I should know, but I don't. I'm kind of just deferring to Mr. Willick,
Okay.
who I perceive as
Sure.
somebody that knows far more about this than I do. But if you allow me the opportunity to look into it and submit a short brief by Friday, I mean, you can issue a ruling by Monday, and I think we'll still be good.
Well, I don't know the deadlines. That's what I'm trying to understand. So
I think for Mr. Willick, it's the 1st of September would be the deadline. Is that right, Marshall?
I believe that if the order is not
Or I
signed
think you told me the 8th.
and sent
The
in,
8th of,
it's whatever his date of retirement is, and we're relying on his application, but it's in the next several
oh, that's
days.
right. He said, and he told us when we were talking last week, I think it was Marshall, that it was September 12th was going to be his date of retirement, correct? So I think we have
I
in
don't
other
have
words
that
until September
information.
12th. Well,
I mean,
when we were
he
talking last week,
normally retirement is at the end of the calendar month preceding the date of retirement. So my guess is that our drop dead date, you'll pardon the expression, is August 31. But I can certify to the court, and I as an officer of the court, I'll just tell you that the deadline for naming wife one is the date of his retirement. If the paperwork isn't done, signed, and sent in before that happens, the opportunity is lost forever.
all right.
So then that would be September 12th, Your Honor, because as I was explaining to Mr. Willick, we did have a phone conference last week, and in the middle of that, I did text my client and ask him specifically when exactly are you retiring, and his answer was September 12th.
Okay. Mr. Willick, question for you. Mr. Gabato has already indicated you're the expert, so I'm going to defer to you on this, at least as much as I can. What are my options if we end up putting wife one on, as you've suggested, and then the life insurance comes up? Can we make those changes post-retirement or not?
No, Your Honor, we wouldn't have this crisis and this hearing if we could have come up with a mechanism that allowed you to make a decision at a later date. To the best of my knowledge, there is no way of altering the designation after it occurs. That's one reason I have Mr. Crane online. He's attempted to deal with there's a mechanism called the Board for Correction of Military Records. It's your way of changing reality in the military system.
Okay.
And he's had more experience than anybody in our office with that. But we did discuss it a couple days ago, and we have never seen a successful effort to do what you just asked.
Okay. All right.
Well, I don't know that that's the case, Charles. I know from personal experience at the Board of Military Records, I don't think they handle that kind of thing. The kind of thing they handle is character of your discharge, or if you were awarded a ribbon that wasn't on your DD 214, that kind of thing. But again, if you'll allow me, I'm not going to explicitly defer to Mr. Willick. I acknowledge that he knows more about this than I do, but if you give me a couple of days, I will give you a full answer. I will either say, yeah, Mr. Willick's correct, and that's what I would feel more comfortable doing, in all honesty, because my client would expect me to do that, rather than say, yeah, I defer to Mr. Willick.
Oh, no.
At this moment, I don't have the answer for you, but I can certainly get it if you give me a day or two, Your Honor.
All right.
And if it's the case that, look, the SPP it's out of the question, we can't do nothing about it after September 12th, that's what I'll tell you. And I'll cite references, and then this court can make a decision by Monday. I think that would be the fairest thing to do for my client.
Mr. Willick, we kind of stopped you mid-argument because I didn't.
And just let me add, I'm sorry, Ron, let me add before Mr. Willick continues that, and I do want to reiterate that, I think the court should consider the idea of latches, that we wouldn't be in this position but for that they waited for a very long time to bring this up.
And
It's
certainly I
not like my
understand that
client
argument, Mr. Gabato. I certainly understand that argument and considered it before I made the last order that I made.
I know you do.
On that point, and just to finish, Ms. Kaufman has attempted to get Mr. Gibb to comply with the insurance requirements for basically since the divorce. He stalled and refused and evaded and denied and simply wouldn't cooperate for all this time. So if the court's going to interpret its order as, look, because of this history, it's his burden, he has 30 days to get private insurance in place, in which case, despite the extra cost, it'll be private insurance, or if not, the SBP will go into effect. If the court wants to, that's the question we actually wanted to get you to rule on, is the meaning of your prior order.
Yep.
Because that was where we ran into conflict.
I think he could get private insurance because he got private insurance for his wife through USAA without the necessity of a physical. That costs a little more, so that's something that we could probably make happen in the last minute.
Let's take a look at those equities then. She has the SGLI. She apparently has private insurance through the whatever it is Mr. Gabato is now talking about that I've never heard about before. And the benefit for wife one is free. So I realize none of this was known to Judge Duckworth when he was trying to weigh equities. He was fed, with respect, misinformation by Ms. Kramer, who said falsely that the SBP for wife one would cost some 20%, I think she said, of the total retirement benefits, and he thought that was ridiculous. But it's exactly wrong. It not only doesn't cost 20%, it's absolutely cost-free under the circumstances as they exist.
Right, which is one of the reasons why I gave him the option to make whatever he needed to do to secure her interest at whatever option was best for him. That's why I gave him that option. So
and he did, Your Honor. He submitted to the test. What happens at this point? I think he's probably going to qualify. It's just going to take a little more time. I don't know how much longer the insurance company is going to take to do this, but
finally,
certainly, Mr. Gabato, I am cognizant of that. The order itself says that he's given 30 days to cooperate in obtaining a life insurance policy. Now, did he cooperate?
And he cooperated.
Maybe he did, but the sentence doesn't end there. We can't stop there. It's for the purpose of securing her insurable interest in the share of the military retirement in the place of the SBP. So it's not just cooperate. It's what we're trying to accomplish is securing her interest. Now, I gave 30 days. Maybe 30 days wasn't long enough. I think we did 30 days because we anticipated the retirement. We wanted to have some time to make sure that if he didn't do it, we would have the time to make this, have this conversation to move forward. But ultimately, what I'm trying to do, is maintain the order that Judge Duckworth put in place. And he may have been misled, but what I've tried to do is give Mr. Gabato's client as much option in doing what he should have done before as he could possibly have. So if we're looking for clarification of paragraph 6 on page 4 of the order that was filed on the 27th of July, it is that she needs to be secured. And the court really doesn't have a preference on how that security takes place. But it needs to take place. And I do not want half of that equation to be eliminated and leave me only the other half of that equation. I don't want to be forced into that circumstance. So the clarification is that I need Mr. Gabato to be aware of what Mr. Willick seems to believe, although Mr. Willick is relying on information from Mr. Gabato in retirement dates as well. I don't know if those documents have been exchanged. But I want to allow him to continue to try and get the life insurance in place for as long as he can. So I don't know what that date is, but you guys can certainly figure that date out. Once we get to a point where we're without options, then the order is what I have in that July 27th order, that she needs to be named in the SBP. So 30 days maybe was unreasonable, so I'll clarify and say that we can go beyond the 30 days, but we cannot go beyond the drop dead date. So, Mr. Gabato, I want to give you the opportunity to figure out when that date is, and hopefully maybe motivate the insurance company or do what needs to be done between now and then if he prefers that option. It sounds like he does. And I'm certainly not going to judge him for that choice. But the purpose of that paragraph was to make sure that she's secured, and we need to make sure that that happens. So is that order clear enough to be able to allow you guys to move forward?
I think it is, Your Honor. What we will do is prepare the relevant order both ways. We'll ask Alex to give us verification, certification of the drop dead date, and we will make sure there is an order on your desk prior to that date with I guess an electronic cover note indicating what we've been told is the date, so that I mean, as a practical matter, the order has to be signed, file stamped, certified, and sent to the military. And we're good, but we can't do that instantly. I mean, that just takes some physical time to accomplish.
I understand. And that's why I say I want to give him as much time as we can to work on that side of the equation. But once we get to a point where the other side doesn't exist anymore, then we've got to make that call.
That's fair, Your Honor, and I will talk to my client, and we will try to make that happen. I think the alternative that he's going to have to consider is if we don't have an answer from underwriting, he will have to probably do what he did for his existing wife at a greater expense to himself.
Actually, frankly, Alex, it's going to save him a bunch of money, but he probably doesn't know that. I can explain it to you, and I can show you right where all the sites are.
Well, yeah, I was going to call you tomorrow, Marshall, in the afternoon. We'll talk about it then.
Okay. Yeah,
okay.
And like I said, Mr. Gabato, I want your client to have those options, and I want him to be able to have those choices until those choices don't exist, and then I feel like my hands are tied at that point.
All right.
All right.
Thank you, Your Honor.
Thank you.
We appreciate it. Do you need anything in writing for today, or can we rely on the minutes for that purpose?
Well, I'm presuming that you're going to submit one of two different orders from today at some point.
Well, an OID was what we were going to submit. The order for today would only be, what the ruling was today. I just wanted to know if you wanted a separate order for that.
Mr. Gabato?
I think we should, Your Honor.
Okay.
Very good. We'll draft.
All right. Perfect. Thank
Thank
you
you.
both.
Thank you, Your Honor.
Thank you for the time, Your Honor.
Uh-huh.